So now let's take a look at some of these lease agreement, the terms that you need to understand, along with some of the basic provisions you see in a typical lease agreement. Obviously, you see that OR and EE again, leaseor and leasee. Leaseor is the landlord, leasee is the tenant. Make sure you keep those straight. But then you see a term here called demise. Demise just means conveyance by lease agreement. So when you sign a lease agreement, what's being conveyed? What are we actually conveying? Because you're not buying the property. So what are you actually conveying? If you again from a much earlier module, we discussed something called the bundle of legal rights, right? The right to use, control, possess, right? There was a few of them, and if you forgot them already, you need to go back and review that. But that's what we're talking about. So when you sign that lease agreement through what we call a demise, you've now conveyed the property rights from the owner to the landlord, right? So, to the landlord. Let me say that again. From the property owner to the tenant. So the tenant now has that bundle of legal rights. That's what we're referring to there. And then you're going to see this term called abandonment. You probably see it a few more times a little bit later on. But abandonment just means 15 days of unexplained absence. Now, there is a reason, and it's important to be able to, if this occurs, to be able to prove abandonment. That we'll be talking about a little bit later. I'm not going to get into it right now, all to into the weeds of abandonment. But you do need to remember, at least for now, abandonment is considered 15 days of unexplained absence. And we'll talk about what this unexplained absence is. But you know as well as I do, sometimes tenants just up and leave. In the middle of the night. They never tell anybody anything. They just disappear. Well, at some point you may have to be able to prove, the tenant abandoned the property. Well, after 15 days of unexplained absence, then we can claim that the property has been abandoned. So again, right now I just want you to remember 15 days, okay? A very critical provision in the leases is dealing with assignments and really subleasing. We're going to talk about both of those. Because remember we said that when we signed the lease agreement, that conveys that bundle of legal rights to the tenant. Well, one of those rights is the right of disposition, right? Meaning they have the right to dispose of their interest. Well, how does a tenant do that? Now, if you own the property, how do you dispose of the property? You could just sell it. And that's your right of disposition. You have the right to dispose by selling the property. Well, obviously a tenant can't sell the property. They don't own it. But they can dispose of what interest they do have. And what interest would that be? They have, my mind just went blank. But as a tenant, they have a non-freehold or leasehold estate, right? They don't have a freehold. Remember, freehold means they own it. Non-freehold, or in some cases you hear it called leasehold, means basically they're renting the property. So when I assign my interest to someone else, first of all, what interest do I own as the tenant? Non-freehold interest, as a tenant. I assign those rights to someone else. Because again, when you assign anything, you can only assign or transfer rights that you own, and all you own is the rights of a tenant under that leasehold interest, right? So then, what is a sublease, or sometimes here called sublet? Again, the right to sublet means to transfer your rights to someone else. Well, then what's the difference between assigning and subletting? This you want to make sure we get it. Not too difficult, but make sure you get it. But there's a very distinct difference. When you assign your interest, once you assign it, that terminates any interest you now have in that property. You no longer have any interest at all. So in essence, now the new tenant, whoever you assigned this to, they now deal directly with the property owner or property manager if there is one. If you choose to sublet your interest, then you haven't actually assigned it to anyone. You're just basically allowing someone else to use what interest you have. So if I sublet, now the new tenant is actually going to pay me the rent. They're going to be dealing with me because I, in effect, become the middleman, right? They'll pay me rent, and then I'll turn around and pay the property manager. So if I sublet, I'm still in the game, right? I still own interest in this leasehold estate. But again, if you assign it, that takes you completely out of the picture, and now it's just the new tenant and the owner. Sublet, I'm still in the middle of it. I'm still, the new tenant will pay me, and then I will pay whatever is due to the landlord. I will tell you, a lot of investors do stuff like this. Maybe I've got this property under lease for $900 a month, but I decide to sublet the property to someone else, and I'm going to charge $1,200 a month. So the new tenant basically is now paying me $1,200 a month, and then out of that I pay the landlord $900. So I'm doing that to make money, right? In that case, I'd be making about $300 a month. You do that on enough properties, you might be making some pretty good money there, and you don't even own the property, right? So that's why you might consider a sublet or sublease over an assignment. Now that we understand what those are, I know some of you are thinking, well, I don't think you can do that. I don't think you're allowed to do that. My landlord said I can't do that. Well, and here's why. First of all, do you have the right to assign or sublet? Yes. That's included in the bundle of legal rights. When you sign that lease agreement through that demise, you conveyed all those rights, and one of them is the right of disposition. However, could the landlord or property manager put in the lease agreement that the tenant does not have the right to disposition? Or sometimes they'll just spell it out and say you cannot assign or sublet. Now, if they put that in the lease agreement, and obviously the tenant signs it, meaning they agreed to it, then basically you've waived your right to disposition. So then you cannot do it. But as long as the lease agreement does not specify that you cannot do it, then obviously you can do it because that's included in your bundle of rights. Hopefully that makes sense. And then you see the term here, sufferance. Remember that tenancy at sufferance or tenancy by sufferance? This takes place basically when the lease is expired, but the tenant chooses not to leave or vacate the property. And in most cases, when they decide not to leave, they also choose not to pay any more rent, right? So that tends to create some suffering on part of the landlord. That's the way I always remembered it. Now I will say, and we'll talk about this some later, but if that happens, then obviously the landlord does have some legal remedies to try to reverse this situation and put the suffering back on the tenant. But anyway, tenancy at sufferance just basically means the lease is expired. The tenant's decided I ain't leaving. And I'm probably not going to pay you any more rent either. So there. Y'all, that's tenancy at sufferance for sure. Y'all, you could have a holdover tenant. Y'all, I will tell you, if you're ever doing property management, either as a property manager or the landlord, or property owner rather, y'all expect to have holdovers. That's part of the business. Expect it, plan for it, prepare for it. But what does this mean? It means a tenant, even though the lease has expired, they have not moved out of the property yet, or maybe they have not completely moved out of the property yet. Y'all, it's considered a holdover. Again, you need to just plan for this. Y'all, even though, y'all, let's say the lease expires on June the 30th. Should the property be vacated by July 1st so that I could put somebody else in there? Y'all, in a perfect world, perhaps so. But I'm telling you, I would not go sign another lease to be effective July 1st with another tenant, knowing there's a tenant still in the property, but they're supposed to be gone by June 30th. You're probably asking for trouble here, and you're going to find it. Because, y'all, you got to be able to work with tenants. Y'all, it is, now sometimes you just got a jerk of a tenant, and they decide I'm not leaving, or I'm going to take my time leaving, and there's really no good reason for it other than they just being aggravating. But a lot of times it's because maybe that tenant, where they're planning to move to, y'all, they can't move in until July the 1st. So there's nowhere for them to go or start moving until July the 1st. So y'all, you need to just go ahead and prepare and expect it, a few days, maybe even a week, after the after the lease expires, for the tenant to still be there. Just plan for it, prepare for it. Now, if they do stay, a few days after it expires, do they still owe rent for those few days? Absolutely. They still got to pay rent for, as long as they still have that property occupied. But they should be in the process of moving. So I find that, if you work with tenants a little bit without harassing them too much, things should work out okay. But just expect it, prepare for it. Don't get all uptight and upset because you go on July 1st and you find they still got stuff there. They haven't moved out yet. They're not gone. Okay. But that's a holdover. Repossess. That says that's the action by the property owner to take back possession of the property. I'm sure you're familiar with that term. But then this term called dispossess. It says that's the act of removing one from the property. So repossess basically is a legal action you take to have someone removed from the property. That's the action you take. Dispossess is when you actually go in and physically grab them by the earlobe and drag them out because they haven't moved out on their own. Now, obviously, should you be doing that yourself? Not if they're bigger than you. No, y'all, you don't do that. I'm just kidding. Y'all, you never, ever lay your hands or even threaten someone else. I'm telling you, even threatening can get you in trouble. Just be careful of that. So y'all, when you go through a repossession, you have to go to magistrate's court, right? That's the legal action you take to repossess, to try to take back possession of the property. Well, when it comes to dispossess, to actually physically remove them from the property, who do you think is going to have to do that? The courts. And the courts will probably order the sheriff or the deputies or whatever to go in and have the tenant removed. You don't do it yourself. So repossess, that's the legal action you take to try to get possession back. Dispossess is when they actually go out and physically pull them out, take them out of the property. Okay. You could have an actual eviction. Some of these terms, quite frankly, are kind of interchangeable, just different terms. But actual eviction, that's where you're physically putting the tenant out. That's where dispossess comes in. But then this constructive eviction, y'all be careful with this one. Y'all, constructive eviction basically is when a tenant is forced out of the property. Y'all, they're forced to vacate the property, but due to the landlord's non-compliance with the lease. In other words, the tenant's been forced to leave because the landlord's not maintaining the property. Y'all, could things start to break and the landlord not fix or repair anything, y'all, at some point, it's not even livable here. There's just so many things wrong. Things are not working. Landlord's not doing anything about it. I cannot even live here anymore. So they're kind of forced out of the property due to the landlord's non-compliance. Y'all, that's called constructive eviction. Obviously, that is illegal. And y'all, the tenant can actually take the landlord to court and sue over constructive eviction. Y'all, and I'm going to tell you, the damages could be quite significant if that should happen, for sure. But then ejectment, y'all, again, eviction. Y'all, in fact, we just talked about this when we're talking about repossession, but y'all, who has the authority to actually evict a tenant? Y'all, to physically have them removed from the property. Y'all, only the courts have that authority. Y'all, you cannot do that yourself, even if you are bigger than the tenant. Y'all, you're going to get charged with assault. And y'all, and like I said earlier, y'all, even threatening words is considered assault. You don't even have to lay a hand on them. So, y'all, as the property manager, y'all, you've got to learn and know how to use the courts. Y'all, typically we're talking about magistrate's court, and let them handle it, because y'all, only the courts have legal authority to remove the tenant from the property. Okay.